I was wondering, when you were talking about the capacities of the ruler in the medieval Islamic society, you were talking about legislation as not one of those capacities. And I would wonder if you could expand on that a little bit, because defining the law was the task of the ulama, but the ruler would somehow adopt certain legal thinking and appoint at least the qadis. Would you, how these things were functioning? I would like you to expand on that a little bit. Thank you.
All right. The practice of Islamic states regarding the law differed to some extent. For instance, in the Ottoman context, although the Shariah was legislated by God as interpreted by the muftis, there was something called Qanun, which was basically a kind of rescript or a law that the Sultan himself would enact, whose legitimacy was doubted by many of the ulama, but was usually to do with things that weren't directly related to specific Sharia issues. They might be to do with forms of land tenancy and issues that were technical and not conspicuously religious. So it was a relatively messy reality in the Ottoman period, but still the theory was quite clear that the ruler had no legislative power, and that the qadi in different provinces had very enormous rights of discretion, certainly when compared to a contemporary judge, because Islamic law is not statutory law. Until the Majalla came about in the late 19th century, there was no Islamic law as we would understand it today. There were lots of Islamic laws, endlessly debated and disputed by the ulama, and in some cases, over centuries, a consensus was reached. In many other cases, a consensus was not reached. And how that law was enacted varied enormously from court to court, from qadi to qadi. Sometimes the ruler may have attempted to adopt a promotions policy that kind of unified interpretations, but in the Ottoman context, usually those positions were granted on the basis of theological eminence or sometimes family connections. It wasn't because the state had a unified vision of the law. Even at the time of Suleiman the Magnificent and Abu Saud, and there's a book about that recently, it wasn't an overall legal strategy on the part of the ruler to interfere with the process of lawmaking. So my point simply was that can't really be replicated in a modern nation-state context, and that takes us on to the second point. The issue facing modern Muslim societies is most of them are working with legal codes bequeathed by former colonial rulers or established by secular minority elites. And those law codes do not reflect either the religious values of their ancestors or the actual cultural needs of the populations. So the application of English common law in a Sudanese village, for instance, is just conceptually very problematic for those two reasons. So in those new nation states, which have to have statutory legislation, it's hard to imagine how the classical Sharia system of having different rulings being given in different courts could actually operate in the context of a nation state or of a globalized economy. They have to make certain choices as to, if we're going to have Islamic law, which Islamic laws, whose interpretation? And this was the decision that the authors of the Majalla took in the 19th century. Basically, it's Hanafi ahkam with a few other things, but which Hanafi ahkam? And very substantially limiting the authority of the qadi. One of the consequences of this is that in modern Islamic jurisdictions like Pakistan, for instance, the decision on which of the various possible Sharia rulings should be chosen becomes immediately a political football. There's no context where it can be done objectively by ulama who are dispassionately disconnected from the hurly-burly of regional or national politics. Politicians will choose a particularly ferocious ruling, such as some of the interpretations of the blasphemy legislation in Pakistan, for instance, because they think that will please villagers and they will get more votes. It's not on the basis of the ulama getting together and understanding the context and deciding which is the most appropriate Sharia option in our situation. It's all to do with jostling for power in the context of a quasi-democratic system where the masses ultimately are the ones who determine which Sharia options the politicians choose. So it's the masses and the politicians who determine the fatwa rather than the ulama. And that's gigantically subversive. That's a kind of hybrid system that is not Islamic and not Western either. So is political Islam not Islamic? I would say it's certainly very far from any of the historic norms of Muslim statecraft. Still, the alternative is not to say that we can't have Islamic laws at all and we should just have Swiss law or French law, because there are serious problems of a cultural disconnect in that case. And the practice of the seerah is a legislative and a legal practice, and that has to be part of the collective life of Muslims.
Amr bil Ma'ruf nowadays is a very subtle thing because people are so weak, and there's always a danger of it misfiring. Quite often one tries to put something right and ends up making people recoil and rebel against religion. We see this politically. Very often the states that attempt to enforce Islamic public morality end up presiding over societies in which there is an uncontrollable proliferation of vice in private. And we saw this in Afghanistan. Anybody who was caught playing backgammon would be flogged and beaten. And the result was that people became resentful against the Sharia, and all kinds of nasty vices proliferated in private. And nowadays we need to be extremely cautious in exercising this principle of Amr bil Ma'ruf, even though for Imam al-Ghazali it's certainly, he calls it a rukn al-a'zam fi din, the greatest foundation of religion, and beaten. And the result was that people became resentful against the Sharia, and all kinds of nasty vices proliferated in private. And nowadays we need to be extremely cautious in exercising this principle of Amr bil Ma'ruf, even though for Imam al-Ghazali it's certainly, he calls it a rukn al-a'zam fi din, the greatest foundation of religion and the basis of the prophetic vocation. Nonetheless, when we do it, and it's a principle that can't be suspended, when we do it, we have to do so with a very careful ability to be attuned to the mentality of the people that we're talking to, lest we incur the sin of their experiencing greater resentment of religion.